Whoever wrote this has got a lot of chutzpah.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, attorney and business professor Patrick O'Malley shows you the good, bad, and ugly of non-disclosure agreements. These are common and hotly debated documents while being fairly standard, so Patrick's 3 tiers of NDA quality reveal a lot. And he's got strong opinions on whether NDAs are even useful or maybe culturally toxic. So let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen. The purpose of the show is exactly what it sounds like. We take contracts, we beat them up, we're mean to them, insult them and their ancestors, and then we lift them up at the end to make them feel warm and fuzzy. I hang out with smart people like Patrick O'Malley here. Sir Patrick, how are you today?
Fine, thank you.
I'm sort of excited, I have to say, about this conversation because every time I ask people what do they want to talk about, they say NDAs, and I find this discussion fascinating because nobody likes them. I'm not sure any of them are even enforceable, but everybody brings them up and everybody's spending so much time with them. So the fact that we are now going to rant about NDAs makes me so happy. We're going to root our conversation. Let me share this document real quick, Patrick. This document from Pace University, a non-disclosure confidentiality agreement, that's going to sort of be the basis of our conversation. But we're going to spin off of it a bit. Before we dig into it, Patrick, what is this document? When are we going to see this thing? You can preface why NDAs are the worst, and we'll talk about it later. What is this document?
Sure. Well, let's start with the narrow. So this particular document, I pulled off the website, but as you can see, it's Pace University, which I believe is in New York State. And so the subtitle of my lecture notes, because I'm a professor, is the good, the bad, and the ugly. So this PACE NDA qualifies as good. Doesn't mean it's perfect. There's even a couple little weird things in there, but by and large, it is head and shoulders above the normal NDAs I see out there, which have all sorts of ridiculousness built into them. Gosh,
and again, having never practiced in-house, I find this fascinating when people tell me this, but the amount of time that lawyers spend on NDAs is just, you would think by now we'd be artists with these things. Well, before we dig into that, and you mentioned you're a professor, tell us about your background. What's your relationship with these kinds of documents? When are you running into them?
Well, I've been a business attorney of one sort or another for about 20 years now. And, but, I've also been a business executive. A recent gig for about 6 years, I ran the world's first incubator for cannabis businesses making products. And so, as you can imagine, I was seeing a lot of NDAs, coming in, going out, and I started to form very definite opinions about those NDAs, and and now I'm teaching MBA students, and so I've kind of started to take a more academic lens to my legal work, and seeing, well, why are we doing these things? Quite frankly, because 95% of the time, they either don't make any sense or maybe they're even socially harmful. But we can get into that in a minute.
Right. So what we're going to do is I'm going to, like I mentioned to you in prep, I'm going to run through this PACE document, but I also want you to feel totally free to nerd out on your professorialness as much as you want into comparing with these other documents, because I do think this framing of the good, the bad, and the ugly is really interesting for these kinds of documents. Before I do, anytime you see a contract nowadays, there's a preface at the beginning that says, what the heck is this even for? I want to get to that. If you look at this PACE document, it talks about to protect the confidential information which might be disclosed. They start with sort of a background. Let's do the same. Let me ask you, in the decision-making process of should I use an NDA, what do you think our first paragraph would be for that kind of analysis, for that kind of conversation? Should we do these things?
Well, most of the time, no. I think as far as recitals go, although this wasn't, specifically labeled a recital, that's clearly what it is. And I'm actually a big fan of recitals, not the kid type, but, the contract type, because at the end of the day, you're writing a contract, and if everything works out, nobody's ever going to read it again. But if something goes sideways, then everybody's going to start reading it. And people who have no idea what's going on, judges, whoever. And so recitals really kind of help keep everybody, on the same page, so to speak. So I think this is a good recital that they got out here. Basically, it's like, why are we even signing this? Well, to protect this information, and that's good. Clear, very clear statement of what they're trying to accomplish with this document.
Well, and speaking of the information, I mean, again, the recital's really rooting that as what we're talking about is confidential information and protecting it. One goes further. It says, as used herein, confidential information shall mean the information described in Exhibit A. It talks about, by reference, this other document that'll be attached. It talks about personally identifiable student employee information. What do you think about Section 1, how they're defining confidential information as related to the purpose of this kind of document?
Well, I think they did a very good job with this. Two reasons. They cite a specific exhibit, so presumably that's going to have a lot more detail. But then, as kind of a saver sort of function, they talk about some more general things like business activities, and obviously personally identifiable student and employee information would be a very worthy thing to protect as much as you possibly can.
Yeah, and it talks about all discussions between, like it makes a default category, all discussions between vendor and PACE in relation to the business purpose, which again is capitalized as a defined term, shall be deemed confidential information. Do you like the catch-all version there?
Yeah, well, lawyers got a lawyer, right? But it's kind of like, why did we go through all this really excellent work with the Exhibit A and, specifying student employee information, and then say, oh, and by the way, everything else? It kind of cheapens the whole experience for me, at least. I don't know how you feel about it, but I feel very let down.
Yeah, and and then you look at 2, obviously, and it makes, some exceptions and says, but it's not these other things. So it has this default of everything's confidential unless we say it's not. And again, I know that throughout this conversation, we're going to talk about the big picture, but thinking of the big picture, is this, you identified this document as a good, the best of the 3 NDAs. If you're advising someone to use an NDA, and you mentioned that the vast majority of the time you don't need it, presumably you think this is a scenario where you do need it. Does this kind of relationship with confidential information, where everything's confidential unless we say otherwise, do you think that fits the purpose that you would identify as a good NDA?
Well, my general feeling is certainly that most NDAs shouldn't be signed at all. And really, what I'm looking for to even justify doing an NDA is some serious hard data, like unique trade secrets, real intellectual property. Like here, there's HIPAA information, or like payment or financial info. Those are all very, important, worthwhile things to protect, or, public health and safety information. And so, I think that if you're covering any of those bases in an NDA, then you definitely want an NDA. And you can certainly throw in all this other stuff, but it's not going to get you in trouble, obviously. But it does seem to sort of water down the whole specificity that they talked about in Exhibit A, or in the in the identifiable information. So, and then in number 2, obviously, you've got all the normal exceptions, court orders, public domain information, that kind of thing. So, there's nothing wrong with paragraph 2 with those exceptions to confidentiality. Right. Those are pretty standard stuff.
Well, and moving to 3, everything is only as good as your, responsibilities that you put on people. It talks about vendor will maintain the confidentiality of the confidential information using procedures not less rigorous than those the vendor uses. The vendor may disclose. There's a lot of control in the hands of the vendor, but to sort of set the terms of what's responsible use of information. What do you think about Section 3 there?
Well, I think actually Section 3 is where the in-house counsel and PACE, and maybe they had a very good reason for this, but just reading this as an outside, non-PACE lawyer, non-New York lawyer, I look at this and say, well, gee, basically, if your vendor is a real slob with protecting his information, then he's not really obligating himself to protect the information. Now, obviously, you also can't say, oh, you have to protect it as much as Pace would protect it, because this guy, this vendor, might be a small businessman, he doesn't have any idea what kind of protections you have in place. So, I think honestly, they probably should just scratch that first sentence or two, as just raising more questions than it actually solves. And I think they created problems for themselves. But that's just my opinion, and you know how it is. A lot of times these are written in there for a certain reason. Somebody had a specific piece in mind.
There's a story. You can tell when there's a story in a contract.
Right. And it's kind of like, bad facts make for bad law. Well, maybe you had a bad fact story that makes for a bad contract provision. But this is the only failure, and it's not a big deal, but this is the only sort of failure in this particular.
And the good one, yeah. And jump into 4. You see this in NDAs a lot. That's basically like, we can't bind you outside of what a court tells you to do, right? And that's what 4 sort of digs into. But the part of that creates additional requirements is that you have to immediately provide written notice of such legal requirement to Pace. What do you think about this as a way to handle if you in fact can't control that situation because of a court?
Well, I think this is definitely a good provision for all parties, and in the bad NDA we're going to talk about later, there's a whole lot of ridiculousness around this particular issue. But here, you're not putting an enormous burden on the person, the small businessman, let's just say, basically, if you're getting a subpoena, you got to let us know. That's not terribly difficult. So I think, again, this is an example of good drafting, which actually, at the end of the day, might actually yield a good result, as opposed to just, paperwork CYA.
And maybe, again, this is me as a novice talking to a professor, but I'm looking at 6, and it talks about superseding and coming above this agreement. It says that basically this is going to last until 5 years has happened, past the talking about the business purpose, and that they have a new agreement that expressly says this supersedes the previous confidentiality, the previous NDA. What do you think about 6 and that way of handling that?
Sure. Well, I think actually they should have used or rather than and, but the point's still fine. But basically, I like this. 5 years is a long time, but in some of the bad NDAs, it's indefinite. Take it to your deathbed sort of thing. And that's just obviously ridiculous. The way I try to explain it to people is, why would you sign a document to somebody you barely know and give them an indefinite, open-ended cause of action against you if it so strikes their fancy? And when I explain it to people that way, they're like, yeah, well, that kind of does make sense. Why would I give people the right to sue me 7 years from now or some ridiculousness? So I like sunset provisions almost inevitably. Almost any kind of contract, I like sunset provisions. And I also just, the second thing I like here with the subsection B is the execution of some sort of future agreement that's going to supersede this agreement. I like that because we know that once we ink a real contract, we can throw this thing away and not worry about it. So a good bit of housekeeping again for all parties. So all in all, I'm definitely going to give. And I love that the Pace lawyers put this in a 2-column format. So when it's printed up properly, it's basically just a 1-pager. I love that. 1-pager, one side. Makes it easy for a lawyer to read it, understand it. And so, high marks for usability on this one. And, I really have to give them, probably, let's give them an A on this one.
Yeah, that's too nice. So let's be mean. I want to jump over to the second document, which you've identified as the bad. This looks like a generic agreement between an investor and a company, and it's got a lot of the same headings, and it seems like the same sort of document, but I'm noticing a lot of highlights in here that makes me think maybe you don't feel like it's the same. Run me through this document. What are you seeing on here compared to the good that you're saying, red flag, pay attention to this?
Well, it starts pretty early. Basically, you got some company and they think they're just the greatest thing since sliced bread. And so much so that they're, deigning to discuss with this investor, i.e. the guy with the money that they're trying to get his money, we're going to deign to talk to you. And here, you're going to sign this thing. Well, here's my first pro tip. The best way to get shown the door when you're at the VC's office is to demand an NDA. They're just going to laugh in your face. And honestly, my way around that, just kind of a practice note, is whenever people ask me to sign an NDA, I just say, no, I don't sign NDAs, certainly just to have a chat with you. Just don't tell me anything that you don't want me to know. Wow, imagine that. Right. Now we don't have to create, a whole piece of paperwork that one of us or both of us might sue each other over in the future. Just keep your big fat mouth shut. Tell me what I need to know in order to have this conversation and whether we'll continue it on. These guys don't obviously, subscribe to my, outlook on the world. So they do all sorts of silly stuff in here. It's kind of like just have fun with it. You want to find some stupid stuff. I think there's probably 6 stupid things in this particular NDA. But I think just the conceit that they're asking somebody to sign anything before this person would be allowed to invest in them. It's like, what do you think you are? God's gift to, venture capitalists? I doubt it.
Well, I was curious in that definite, the first, remember in the previous document, the definition was everything's confidential unless we say otherwise, and here's some otherwise. In one, it's got a pretty broad stroke there. It includes that any information independently obtained or prepared by the investor. So it sounds like they're even saying if you, investor, are doing your own research into us, you can't talk about that either. What do you think of that section?
I had a good laugh. It was humorous. I mean, taken against the background that they shouldn't even be asking this guy for an NDA, and then they're saying, "Oh well, anything that relates to us, even if you dig it out at your own time and expense, is still protected by this agreement." I mean, I don't even get the concept of how they conceive of that. Honestly, I just got to wonder who wrote this silliness. That's rich. That when I saw that one, I was like, oh, I'm using this one because this is literally the most ridiculous provision I've ever seen in any NDA.
Yeah, well, again, sort of, you can tell who wrote this document. Looking down at 4 under the governmental orders and requests, similar to the previous, they are saying, look, we can't stop courts from requiring things. But they say on there, investors shall cooperate with the company in an effort to reasonably limit the nature and scope of any required disclosure of confidential information. Very different language in the sense that it's now putting the onus on the other side to be the adult in the room. What do you think about that requirement?
Yeah, again, they just continue to be presumptuous. Quite frankly, it's like, first of all, what kind of cooperation do you need? Do you need me to go out and hire my attorney to try to quash that subpoena or that, whatever it is, that court order? It's just bonkers. Contrast that with the Pace University, where they said, hey, your active obligation ends by giving us written notice so that we know what's going on. These guys basically want you to become, a party to some action. Or at least could be argued that. So again, this is a real clown, whoever wrote this is just a clown, and anybody who signs it is dumber than a clown.
Yeah, it's probably like my brother or something wrote this, and I'm going to have to apologize to him later. Looking at 6, it talks about the accuracy of the confidential information, and part of me is like, this feels like there's a story here, and they included this. And part of me is like, what is this trying to do? It says, by executing this agreement, the company makes no representations or warranties to the accuracy or completeness of the confidential information provided to the investor. Like, what is that even doing? What is that section even doing?
Well, I'm going to say, whoever wrote this has got a lot of chutzpah, because basically they said, okay, everything we tell you is going to be confidential. Everything you figure out by yourself is going to be confidential. And oh, by the way, all that stuff that we told you, you can't count on any of it being true because we're expressly disclaiming and, we're just washing our hands of this thing. It's just the silliness.
And here's the investor saying, I'm just having coffee, right? Like I think I'm just having coffee with a person with an idea. And now I've got to sign this thing that says you're totally full of nonsense. And speaking of sort of the scope creep of what NDAs do. I know you wanted to talk about the ugly. This is a fascinating document because it is not what it says it is. Tell me about this third document and sort of how NDA scope creep and NDAs solve all social ills is now being turned into something totally different. What is the ugly?
Mm-hmm. Well, okay, yes, the ugly, as I was doing the research for this, a good solid maybe third of the NDAs that I was able to kind of just uncover in the public domain were real estate brokers. And I've on and off been a real estate broker for, let's just say, more than 2 decades without getting into specifics. And so, I'm looking at that going, well, okay, realistically, at the end of the day, a broker is just an information conduit. He's passing information from seller to buyer in essence. And so why does this really need an NDA? Again, you kind of wonder, what's the point of even doing an NDA? Doesn't the broker want to sell this property? Of course I do. So why would they try to limit the scope or the audience that might want to buy it? But as I started digging into the real estate NDAs, is that I realized that they weren't NDAs at all. Basically, although they have non-disclosure written at the top, that's just a tiny fraction of the heavy lifting and serious contractual relationships that are being created in this document. So although there is a non-disclosure in here somewhere, there's a whole lot of extra stuff that definitely shouldn't be here, period, because there are other specific forms issued by state real estate regulators that would cover a lot of these eventualities.
Yeah, there's information in here about an escrow deposit. Like this is very different. And I guess getting to the big picture, what I'm seeing, and correct me where this is wrong, but what I'm seeing is like the universal applicability of the holy and righteous scripture of NDA. People are stretching these things past the point of credulity. But I also feel like the nature of contract, the purpose of contract is to get two people who are not part of the same tribe, not part of the same family, have no reason to cooperate, to create enough trust that those people feel safe cooperating. What is the public policy sort of view of an NDA that it can do sometimes that work of creating trust where trust is not, but sometimes it actually undermines the trust that it was meant to create? What do you think about the big picture of the NDA?
Yeah, well, pulling way, way, way back and viewing the forest now, I think there's probably the first distinction we need to make is, although these three that we've been talking about are, let's call them commercial NDAs or business NDAs, where there is a business purpose. We do see NDAs used in other ways, and I'm going to just call them, for lack of a better word, personal NDAs. And, this got a lot of press. And as I was doing my research, I was reminded of it. A lot of press with the Harvey Weinstein and the Donald Trump NDAs, where, these NDAs were used by, wealthy, sophisticated, well-represented individuals in order to basically browbeat, non-sophisticated individuals and in order to cover the tracks of the disreputable wealthy individuals. And, that's very broad, but, you get the point that why should the courts or even the threat of courts be permitted to basically, in essence, eliminate an individual's First Amendment rights. And although, power to contract is obviously very, very, very important, there are plenty of contracts that we're not going to enforce because, they're against public policy. We're not going to enforce a contract that envisions an illegal activity. And so, I think that, with these personal NDAs, I think that absent, showing of some clear, compelling socially legitimate need, I think a very strong argument can be made, and I've read a few law review articles to this extent, that, good public policy should say, we're not going to enforce a personal NDA, kind of like how California disfavors non-compete employment clauses. And I think a lot of people look at that and go, well, yeah, that makes sense. We don't want to basically, chill people's abilities to go out and, get another job. And, I think as bad as a non-compete in an employment situation is, so bad that the state of California said we don't want to countenance that. I think it's much, much worse when you're talking about a personal NDA, where it's not just about, we don't want people to compete with us. It's far more nefarious than an employee non-compete. And so, yeah, you really have to really think about that First Amendment issue. For example, perhaps an NDA that protected the privacy of a child actor. Well, I think you could probably make, a good public policy case for that. Like, well, he's still a minor, and so, we don't want, them to be splashed all over the news. But, on the opposite side of that, definitely not. We definitely don't want bad actors to use NDAs to cover up their bad acts, especially if we're talking about, something potentially criminal or tortious, sexual harassment lawsuit settlements. I think that right there, when you're asking that person to sign an NDA, you're basically saying, yeah, we kind of want to go out and do it again. And so we don't want to get caught. And so we want to chill your speech so that you won't talk to anybody. And I think when I frame it that way, I think it's pretty easy to agree that it is a misuse of the courts to allow a bad actor to get away with a misdeed by hiding behind the power of the court. And, at the end of the day, the Aspen Times newspaper has back when Hunter S. Thompson was the editor, or the contributor, whatever. They had a great motto, and the motto was, "If you don't want it printed, don't do it." And I think that pretty much covers the waterfront for personal NDAs. And I think lawyers, not to be old-fashioned, but lawyers as officers of the court, I think you need to ask yourself, why is my client asking me to draft a personal NDA, that they're putting upon this, person of no means, or this naive person? And, am I enabling, am I using my law degree, my profession, my status, my, status as an officer of the court to, basically enable someone to commit future bad acts? Well, I think with Harvey Weinstein's lawyers, that's a definite yes.
Yeah, and I don't know that those lawyers were asking those questions. But I do, to your point, there's a power dynamics question here, right? Like, who's got the power in the situation? Because a lot of that might define some of this public policy righteousness that you're talking about. But in the case of a small, I have an idea, I want to start a company, and I go to the big investor. I mean, the nature of that relationship is the person with the idea does not have the power in that situation. The person with the capital has that. The ideas there are many, and there's not much capital, right? So that's a different power dynamic. It sounds like you're disfavoring even that small, founder from trying to use an NDA. Are there other ways for that person to protect their, to not be taken advantage of by that disparate power structure?
Well, in all honesty, it's a practical matter. Now, could there be, you came up with some gambling system that never fails, and it's, just the simplest thing in the world, and once you tell the other person how it works, then, they could run off and take your idea and cut you out. But that's just not the real world. The real world is you come up with an idea, I come up with 3 ideas before lunchtime, right? But, until somebody's actually done the legwork and executed and taken all those twists and turns that they need,
sure,
you really don't have much. And, the big sophisticated company, again, isn't actually, they make quite a clear policy that they don't accept unsolicited ideas because, well, they don't want to open themselves up to this. And so I think that for all those people with a great idea, that's great, but until you've got some real sales behind your great idea, you definitely don't have anything worth protecting.
Yeah. And the majority of those ideas are iterative anyway. They're not actually disruptive. We've got this weird cult of everything's got to be disruptive, but the majority of human progress is iterative. So stop thinking you got to break everything and everybody cares about the way it gets, because that's actually very rare. Well, I think it's interesting. I'm glad we finally on this show have gotten to talk about NDAs, especially from the perspective of why the freak are you guys all doing these things? You all hate them. I just find it fascinating as like a social experiment, why you guys are all doing NDAs all the time. So I appreciate you sharing your perspective on that. For people who want to reach out to you and learn more about your work, teaching the MBA students and your experience with documents like this, what's the best way for them to reach out to you, Patrick?
I'm an email kind of guy. I'm that generation. So I don't know if you've got a little ticker down at the bottom there. You can put my email address, but just put my Gmail, and that's where it all lands eventually.
We can, and we'll have it there. We'll also have it at lawinsider.com/resources, where the blog post will live that will talk about this issue of the NDAs. And if you want to come on the show and beat up contracts like we do, just email us. We are at community@lawinsider.com. We'd love to have you. Thank you again, Patrick. You guys, we will see you next time.
Good. Nice chat, Mike.